I can't hear you.
Okay. Also,
Number 2, Peterson and Peterson. Judge Fassett ruled last week because I was in trial, set it over in case I had additional information. Seeing as she's not here today, I think it can be stricken. I'll note it back on a date in the future in front of her.
all right, anybody else here on Peterson and Peterson?
I am Melissa Peterson.
All right, Mr. Baldwin has asked that this matter just be struck today. Any objection to that?
I do object. We could have struck this last week and set it over to something else. This has been continued matter. It's been almost a year now.
Ms. Peterson prevailed on accelerating her visits to the next step in front of Judge Fassett. She ruled, put it on today's date because I was in trial. Ms. Baldwin didn't know if I had additional information to provide to the court. Judge Fassett set it on, I think, not realizing she'd be out in trial. There's nothing I can argue to, Your Honor. She's the one who heard the hearing. At this point, I don't have anything to add right now. So her order stands as far as I'm aware. I don't think she set any presentation dates. So at this point, Ms. Peterson has moved to the next phase in visits, was my understanding from Ms. Baldwin's covering at the last calendar. So there's nothing before the court.
It was to review the 50-50 plan, Your Honor.
She made a motion for the 50-50 plan. Judge Fassett granted moving forward on visitation, but did not have it on today to address going beyond. Ms. Peterson just got an evaluation that was ordered by the court almost a year ago, has not completed all of the recommended counseling from that yet, nor has she done the hour-long visits, but neither here nor there, Judge. My understanding, Judge Fassett ruled last week, left it on for review if I had anything to add. So I don't think there's anything to add for Your Honor. So I think it can be stricken, but if the court wants to put it over another week or 2 weeks in front of Judge Fassett, I'll defer. But I think that what would have been reflected in your review of the matter, I think, on the docket in Odyssey.
All right.
Your Honor,
Yeah,
Your
go
Honor,
ahead.
Ann Height, guardian ad litem.
Yes, Ms. Height.
I've been on this matter and it has been delayed repeatedly. And I would urge the court to get this settled sooner rather than later. This daughter has been waiting a long time for resolution.
All right, thank you. But it sounds like Judge Fassett is in the middle of making some decisions. I don't think I can really get into what her thinking is on it. So the best I can do is set it over 1 to 2 weeks. My inclination is to set it on April 11th at 1 p.m.
And that works, right? I'm out of the state next week,
Okay.
so I'm not available.
All right, so number 2, Andrew Peterson and Melissa Peterson will put over to April 11th at 1 p.m.
Thank you, Judge.
And hopefully it'll get resolved at that time.
And number 9, Your Honor, Leedy and Leedy. That's on for a GAL review today. We did hear from Miss Fellows recently, and she sounds like she's working the investigation, pending a couple of mental health evaluations for both parties. So I don't know that we can necessarily go forward today, allow input, I guess, or suggestion for Miss Fellows on how long she believes that will take the parties. I do understand that my client has received her mental health evaluation as of the end of February. We're just awaiting results from Dr. Johnson's office down in Vancouver. I've instructed her to reach out and get an estimated time that we can expect those. So hopefully that will be forthcoming.
Ms. Fellows, any time frame?
Unfortunately, I don't. I had heard from the mom that she had been in connection with Dr. Johnson, but I haven't seen the evaluation. I have not heard from the dad about whether or not he has completed his evaluation. So I'm kind of at a stuck place on, I can't move forward until I get those evaluations. That was ordered by the court on December 7th of 2022. So that's kind of an integral part of my investigation. I could suggest setting it out 60 days. So that would be about May 23rd. But that would be my best suggestion.
Mr. Zandy?
I don't have any issue with that. I don't need to have resolution, and there's not much my client can do about that. I think it's just kind of sit back and wait, for Dr. Johnson to issue his findings in his report. And at this point, there's not much we can do except sit back and cross our fingers and hope that that's sooner than later. I don't have any opposition to May 23rd. I was hoping it could be sooner than that. But then again, I don't know where Mr. Leedy is on his evaluation. I haven't heard any updates on that.
Mr. Anagnosti, any thoughts?
Yes, Your Honor. My client is in the process. He has got an appointment for his evaluation. He just hasn't been able to get in to see somebody. And so we were going to ask that this matter be set over for him to complete the evaluation. He's been attempting to get that done as soon as possible. May 23rd. I mean, that's a ways out, but
Ms. Fellows, personally, I would prefer May 2nd to have everybody check in,
Okay,
and that will hopefully motivate everybody to get their evaluations done.
okay,
So in Leedy versus Leedy, we'll set a review then for May 2nd at 1 p.m.
okay. Thank you, Your Honor.
So let's go
Very
on
good,
then
Jonathan.
to McCaven Mendoza and Lillian Aldrich.
I'm ready, Your Honor.
All right, Ms. Turnbull is here,
I'm here as well.
and Ms. Aldrich is here. Ms. Gilmore is here. I don't know if you're aware, Ms. Turnbull, I heard this on the minor guardianship docket, and I terminated the minor guardianship relating to Maverick.
Yeah.
Okay.
Miss Farr gave me a call after that docket, so she let me know.
Okay, thank you. So I think we're here today on I guess a visitation plan, or what it says in my docket is a restraining order relating to this case. So I'll let Ms. Gilmore go first. Then I think I'll hear from Ms. Aldrich, and then I'll hear from Ms. Turnbull.
Yes, Your Honor. Procedurally, I would like to note that Ms. Aldrich hasn't been personally served with a restraining order. I received a notice from the clerk's office out of concern for jurisdiction between Oregon and Washington in the service of the sheriff's office. So I do acknowledge that this is a pretty short turnaround, and she does want to continue to provide a response. In the interim, we are agreeable to non-professional supervision. My client is offering for his mother to provide supervised visitation every other Saturday for a 4 to 6 hour period, just to get some sort of contact going. We would like to see a clean replical prior to visitation commencing. It does sound like from Ms. Farr on the guardianship docket that mother has engaged in a urine analysis. So hopefully we'll be able to get that in short order. But yeah, we're asking for supervised visitation moving forward, or alternatively, just extending the restraining order, keeping the child in my client's care, allowing Ms. Aldrich the opportunity to respond, and then addressing this in another week or two. One last thing, Your Honor. Regardless of the situation, I do think that my client is current primary parent. There is a child support order for a transfer payment from my client to mother. I would just simply ask for a bench order terminating that as of the date the guardianship was entered. And I believe that was at the beginning of February.
So you want to terminate the child support order as of February 1?
Yes.
Ms. Aldrich, what counsel just indicated is that Mr. McCaven would be or Mr. Mendoza would be the primary parent. They would agree at this point to non-professional supervised visitations with Mr. Mendoza's mother on every other Saturday from 4 to 6, and request that you do a hair follicle test. So would you like to respond to that?
Well, I don't feel like if I'm thankful for any time I'm going to get with my son, but I don't feel like one day a week every so often is going to do it. I mean, my son has been with me since he was born, and it has been a dual effort as to why he has been absent in Maverick's life. But I'm more than happy, and I'm thrilled to have him be in his life now because he needs a dad. But Maverick's used to being in with me. He's with his sister. We have our own situation at home, and as of right now, if this is all we can get so far, then I'm more than willing to cooperate. But I definitely plan on continuing and doing what I best to at least get 50-50 so we can share our child that we do share. And hopefully I want the restraining order to be maybe dismissed so I can at least talk to my son. I haven't been bugging anyone except for I texted the other petitioners quite a few times trying to get the chance to be able to see them, but I haven't been bugging anybody else around the situation because of the restraining order. And now that anything has been like changed or slightly lifted, I'm wanting to definitely reach out with no risk of getting in trouble. And just didn't want to do anything to come in the way of that.
Is there a temporary restraining order in place?
No, it's just the immediate restraining order, and that's not a no contact order. That's just a do not disturb, do not come in the vicinity of. I'm happy to facilitate some sort of FaceTime or telephone call in short order if the court is interested in setting this out and holding off on a temporary parenting plan until we receive a response. I also would just defer to the guardian ad litem. She might have more perspective on that.
Let's go to her then. Ms. Turnbull.
Yes, I think it would be appropriate for Ms. Aldrich to have a hair follicle test and for the urinalysis results to come back from CPS. There are two urinalysis results that are still pending, and we're waiting on those. And so I think that the supervised visitation is appropriate. I also think that we need to make sure that Ms. Aldrich isn't using, and that whoever is supervising the visitation can stop the visit if there's any concern, pardon me, that Ms. Aldrich is under the influence.
I have raised my children both their whole lives, and there's never been a safety concern. There's never been anything as to risk them or anything like that. And even if things had occurred, which they did, and I dealt with that situation at hand, and Washington had the opportunity to pick up the case with CPS, and they chose not to. And after that, things have been different. I've had my son his whole life, and my son, I know, will like it there, of course, but I feel like this is not what's necessarily best for my son, but I'm willing to do all I can to prove to you guys that I am what's best for my son. And like I said, at least 50-50 was something that I'd be more than willing to be okay with. But my son's home is with me and his sister. And this has already been through a lot, and I want to be there for him and be able to help him and get him to do the things he needs to do. And also remain primary because I've had him his whole life.
Okay, Ms. Aldrich, the issue I think for the court is the court needs objective verification that there's no substance abuse issue.
I understand that, and I've been talking to the other guardian ad litem too, and I'm trying to help them get recent ones as well because of the ones I've been taking. But I don't know why they're taking so long to get back to you guys, but I wish that they would get back sooner so that I can prove to you guys that it's not an ongoing issue.
Okay. I'm not going to enter a temporary parenting plan. I think we need more information in order to do that. I do want this to move along fairly quickly. I do want to have some contact between Maverick and his mother between now and when we set the next hearing. So I'm going to allow non-professional supervised visits with Mr. Mendoza's mother as a supervisor on every other Saturday from 4 to 6 hours. I'm going to let Ms. Aldrich and Mr. Mendoza's mother determine what those 4 to 6 hours will be. The first one will be this Saturday. I'm also going to require that Ms. Aldrich do a hair follicle test. Today's Tuesday. I'd like that done by Friday. And I'm going to set the next review for April 18th at 1 p.m. And if the UAs and hair follicle tests come back negative, then I would expect a substantial visitation time with Ms. Aldrich would be ordered at that hearing.
Thank you.
Okay. All right.
Is the court able to enter a bench order to that effect on those provisions? Just because since the restraining order will be terminated today, then no one will technically have custody of the child. Or alternatively, I could prepare something ex parte and try to get it to the court tomorrow.
We don't have to necessarily do that. I'm more than I'm happy, very happy. But I also understand that Maverick's most safe and ideal place right now is there, and I can respect that. I'm not sure if the courts can take that, but I can expect and fully respect that is what is going on right now without having to fill out another motion.
For a couple reasons, on my pro se dockets, I do all the bench orders, so I'll go ahead and do a bench order in this case. Also, I'm leaving Thursday and I'll be gone for a week. So if I happen to miss that order, it'll be a while before I sign it. So I think it's going to be safer if I go ahead and do a bench order on those provisions. Okay. All right. Thank you. We'll see everybody back here on April 18th on that case. And this is to establish child support. Ms. Gilmore, where are we at in this case?
So yes, it's before the court on both a motion for parenting plan as well as child support. We originally brought the motion for parenting plan to adopt the current status quo of my client having alternating weekend visitation. Subsequently thereafter, we received a notice from DCS for an administrative hearing. And so then I brought the second motion to address child support in the Superior Court rather than through the administrative process. I haven't received any sort of response from mother in this case. She did appear at the administrative hearing and is aware of today's hearing as that was discussed there, and she received notice. But absent a response, I would ask the court to grant our proposal.
What I have is, if I got this right, the child support would be at $444.22. Is that correct?
Yes.
And as far as the tax exemption, the respondent would have odd years. That would be 2023 forward, and the petitioner would have even years.
Yes.
Okay. Is there anybody else on here on Justin Talley and Zoe Hoffman?
I did ask for, sorry.
I will agree to that. I don't have an order with me though. It's
I expected her to appear just because she appeared at the administrative hearing, and I honestly expected her to respond. I would ask for a start date of April 1. This is on our motion, and then the final orders in 2020 didn't address any sort of child support, so I think that's appropriate. I would like to also make the court know, and I thought that mother was going to argue this fact is DCS wants to address back support based on the start date. So I would ask that my client be found to be current as of April 1 on support, and then the support obligation moving forward starts April 1 of the $444.
Tell me more about why the Department of Child Support wants to have a past due.
So it sounds like mother didn't bring a motion. So the underlying final orders in 2020 reference the fact that either party can bring a motion. It doesn't even necessarily reserve on that. Neither party did so. They reconciled, were living together for a period. And it sounds like sometime between 21 and 22, mother notified DCS that she wanted an administrative order of child support. However, my client didn't receive notice of that request until this year. And so there is a potential back support obligation of some amount that's still outstanding. However, based on the, procedurally, we were before a Superior Court, no one brought a motion. I don't think that it's, and given the fact that the parties frankly live together, I don't believe any back support is appropriate in this case.
Okay. All right. I'll indicate that the mother is current to April 1. The order will begin April 1.
Sorry, Your Honor, father is current. You said
father is current to April 1, and it will begin April 1. And then can you provide a order to that effect?
Yes, I'll enter that ex parte.
The last thing is there was a request to change the daughter's name. Is that before the court now? I saw that request in the file.
So that was, yes, that is included in our motion to address both the parenting plan as well as the name request. Again, the final order is reserved on that request. And so I do think we have a basis to make that request now. I'm a little apprehensive given the fact that mother isn't present, some of the concerns procedurally with that. If the court wants to continue to reserve on that, I think that might be fair. And then we can address that on some sort of final basis.
Let's do that. I'd rather have the mother weigh in on that decision. Okay. All right. When the orders arrive, I will sign them. Okay.
Thank you.
Thank you.
Yes, Your Honor. I was coming before the court to ask for the temporary restraining order to be dropped. I'm not a danger to. I'm absolutely not a danger to my children. I'm not a danger to my soon-to-be ex-wife, or anyone for that matter. And it is blocking me from even knowing about how they're doing in school. And as I mentioned. I don't know where Megan's emotions are coming from, but she has not told me where Liam goes to school. She refuses to answer any questions about the kids. So I'm just trying to do what I can to be in their lives.
Okay. Thank you, Mr. Hitchcock. Ms. Bliss, are you on this, or Mr. Zandy's on this?
No, it's me, Your Honor, and to please the court, I do represent the respondent, non-moving party to the motion before you today. Megan Hitchcock, we did file for your review my client's responsive declaration to this motion back on March 20th. I think she lays out some pretty significant grounds for why she's asking the order to remain as is. I would note from a legal and factual basis, we think the affidavit on its face is insufficient. I don't think it complies with what the law is as it relates to that. It's a restraining order that was entered last summer by Judge Hahn. And this is a case in which at the time Mr. Hitchcock was represented by counsel. Both of them appeared at the hearing. Mr. Hitchcock submitted a 9-page declaration on his behalf, which pertains in large part to the request for not only the restraining order, but also as it related to the care and visitation of the children in this matter. And the court found sufficient grounds to grant another restraining order. And to suggest that that be set aside because he had insufficient notice, again, flies in the face of reason. Also doesn't comport with what the pleadings will provide for you, which is he was present, as was his then attorney. Now, there was no motion for reconsideration. Matter has sat idly by since it was entered back in August. And again, here we are now in March, Mr. Hitchcock representing himself, asking for a relief that just isn't afforded under the statute. My client does give you grounds for why we believe that that should remain in place. Now, this is a case in which Mr. Hitchcock was court ordered back in the summer to undergo a psychological evaluation with input from the GAL, who is Ms. Height, as well as my client. And to date, my client has received no information pertaining to that. Now, she hasn't been contacted by any providers. We certainly have not received any kind of written documents or any kind of evaluation on Mr. Hitchcock's behalf. And that is still largely up in the air and has not been complied with. At minimum, we should see what the results of that psychological evaluation are before we address these types of issues. My client also gives you information about the snowmen. Understand after reviewing Mr. Hitchcock's mother's declaration that she's claiming to be the person who dropped those off at the home, but that was obviously concerning to my client, in which she responds, returns to the home after dropping the kids off at school, and there's on a day where there's no snow in the lower elevations of Longview, 3 snowmen. Checks the video cameras and views what she believes is Mr. Hitchcock's car pulling up, and someone who's can't be ascertained who it is, and puts 3 snowmen on the front yard while the kids are at school. That's highly unusual. That's bizarre. There's been other communications that have her concerned related to Mr. Hitchcock. As she states for you in her declaration, there is fear from her that he continues to surveil her about her comings and goings and where she's at. Continues to violate the order. The order is very specific. The only communication is over the parenting app as it relates directly to the children. And Mr. Hitchcock is basically trying to relive old memories with her, again, addressing things related to the relationship and the past relationship during the marriage. And again, my client obviously has a sense of uneasiness when it comes to that. Now, given where we're at on this, doesn't make a lot of sense from my client's perspective to eliminate this or terminate the restraining order, which again has been in effect for some time. If you look at the terms of that restraining order, you'll see that it's set to expire in late May of this year. Again, that's 2 months away. One could logically assume that it probably makes the most sense in judicial economy to just let that ride itself out until May. Work towards getting that psychological evaluation, see what the results of that are prior to making any decisions on this. But again, this kind of goes to my client's concerns about Mr. Hitchcock's emotional and mental well-being at this point. And we're at a point now where we're erring on the side of caution and safety. That makes the most amount of sense. And that's what my client is asking you to do today. We do believe this is improperly before the court. This is now the 3rd time we've been here in the last month and a half or so. Court did not impose any fees at the past 2 hearings, which were related to discovery issues from Mr. Hitchcock. We are asking the court to contemplate some award of attorney's fees and costs. It also informed the court, as you probably know, that there's now a pending another compelled motion that Mr. Hitchcock has filed on his behalf. Instead of consolidating these matters and hearing these in one judicial proceeding, we're now forced to come back not only today, but again in a week or 2 on the compelled motion. It comes at an expense to my client. She simply can't afford it. We are asking for a contribution towards fees and costs.
Your Honor.
Mr. Hitchcock, before you speak, I'd like to hear from Ms. Height.
Good afternoon, Your Honor. I do believe that it's going to be in Mr. Hitchcock's best interest to get that psychological evaluation. I think that will provide tools for him going forward that will help him in the future when he parents these children. So I feel like we need to wait until we get that. I think it's going to be in everyone's best interest. I did review the information about the snowmen. Frankly, it seemed silly to me that it became an issue. The picture that I saw was basically a few snowballs in somebody's yard. It didn't seem threatening at all. However, I do understand that having him or someone on his behalf, if that's what happened, show up, that is troubling and should not happen. I'm not sure that there was any kind of evil intent by grandmother's part. I think it sounded like kind of a spur of the moment idea of hers, and I don't find it particularly troubling. However, I don't think that rescinding the orders that are in place now are in the children's best interest at this time.
Thank you. Mr. Hitchcock, you may respond.
Your Honor, just allow me to compose myself. I'm sorry for laughing earlier. Earlier in this motion, not in this motion, earlier in this court, we heard somebody talking about a psych evaluation that was ordered December 7th of 2022 that they have not had that yet. The psych evaluations are out over a year. I got on the list as soon as I can. Ann knows that. Diffuse why Ann is here speaking on behalf, because she told me that she's done with this case. Furthermore, I've never broken that restraining order. I'm not crazy or dumb enough to go anywhere near Megan. I only found out that my mom did when I got Megan's responsive declaration. Again, I will go back to the original matter when she did write her declaration. She did perjure herself, which she does over and over again. But she said that Ann Height directed her to not bring my son to visits, and he wasn't coming. And then she made excuses for that after it came forth that Beth Fellows didn't have her. So she took this on herself to keep my son from me in my supervised visits, and then used that as an excuse to further push me away from my children in a restraining order. As well, the fact that she says that she has video evidence where she clearly sees my car. And then again, when she says that she is certain that I'm surveilling her. Your Honor, I have had that car since July of last year. Megan and I we've not seen each other since that time. The only way Megan knows what my car looks like, one, is to surveil me, and two, my car was not there. It was my mom's, as she said. And there's been like 3 times my mom has driven my car, and I asked her, she said she's certain it wasn't my car that she took that day. Then when I revisited Megan's testimony to find out where I was, what I was doing, she says on February 20th, the kids had late start due to weather. February 20th was President's Day. There was no school. And before I found that out, before I realized that, I checked, and I was out of town that morning of the night before. And then I did call the school, and I just called Long Beach School District, because once again, Luke's school won't talk to me about how he's doing or what's going on. They said the only late start was February 16th. That day as well, I was out of town. It's not my car. Megan purposely, once again, she is lying about this video. Neither my car nor I was there. My mom and I both have a red sedan, but it's very different. My mom drives a 2007 Chrysler Sebring. I drive a 2018 Ford Fusion. Once again, I've never broken that restraining order, and my car was not there. And once again, Megan's doing everything she can to push me away from these children. Luke is 5, Liam is 4, Mario will be 3 soon. Every time I see Liam, he has to come to my house. Luke sometimes cries when he leaves visits. I'm concerned about their well-being, and I'm just trying to check up on them at school.
All right, thank you, Mr. Hitchcock. So we're not here to decide whether the restraining order is entered in the first place. That was determined almost a year ago on whatever facts were before the court at that time. I didn't make that decision, but I come to this case with the restraining order already filed. Mr. Hitchcock has asked that be dropped. I'm going to deny that request for 2 reasons. One is it's going to expire on its own terms on May 24th. That's not that long from now. And it may happen, it may not, but if Ms. Hitchcock asks for a renewal, then all of the arguments that Mr. Hitchcock has discussed with us today would be relevant in that discussion. But because it's going to expire relatively soon, I think it should remain in place. Secondly, both Mr. Zandy and Ms. Hyde have indicated that there needs to be a mental health evaluation. I did see that in the file, and apparently one has not been done since it was ordered. And the court is hesitant to make any changes until that evaluation is done. So what I would suggest, Mr. Hitchcock, is I think you should get the evaluation done. I think you should anticipate that Ms. Hitchcock may be asking to renew that restraining order, and it will be helpful to the court to have a mental health evaluation done before ruling on that renewal motion, if it's brought. But I think we should look ahead, and I'm going to encourage that you get that done as soon as possible. Otherwise, for today, I'm going to deny the motion to lift the restraining. Okay.
Can you just enter a bench order to that effect, Your Honor, so we don't have to come back?
I will do that.
What does a bench order do?
It's an order that I draft that will say simply that I denied the motion to lift the restraining order.
Okay. I do want to say for the record that what Megan is doing is hurting these children, and that is my primary desires to help my children.
Okay, I accept that, sir. First of all, I'm prepared to go forward today, but I saw there was another hearing on May 2nd. I didn't know if it made sense to line these up or not, but if not, we can go forward today.
Your Honor, it'd be my request to move forward today is, at least with regard to the FaceTime issue, that definitely needs to be resolved as it's been outstanding for several months. And secondarily, I think the hearing on May 2nd is for a final GAL report review. I think we're still outstanding at least one evaluation. So whether or not that's actually going to move forward on that date is still questionable. So I would ask to move forward today.
Okay. Ms. Jeffers, any response?
No objection to moving forward today, Your Honor.
Okay, very good. All right, Ms. Bliss, is it your motion?
Yes, Your Honor.
All right, do you want to begin?
Absolutely. Thank you. For the record, Carly Bliss on behalf of the respondent and moving party, namely Jonathan Bolt. We're before the court today on a twofold request, one of which would be a point of clarification and or a modification to the existing parenting plan as contained in my client's declaration. The temporary parenting plan addresses the two issues before the court today, first of which being the FaceTime visit. I'll address that matter first. As contained in Section 8, it is specifically indicated that my client will be provided additional visitation via FaceTime. It's also addressed in Section 14 as to reasonable times and duration given the child's age. My client provides for the court that prior to that hearing, the court largely adopted the status quo between the parties relates to the visitation of Hudson. Prior to that order, my client indicates he had been exercising daily FaceTime visits with the child. There was an incident between the parties in January of this year. Since that time, he's received 0 FaceTime visits, which I think is contrary to the order of the court. Instead of bringing a motion for contempt, he's simply asking the court to provide a little bit more clarification to that order and indicate specific dates and times in which those visits should happen, given the confusion or the blatant disregard for that order on the behalf of mother and her third party, Emma. In my client's request, he indicated Tuesday, Wednesday, Saturday, and Sunday at 5:30 p.m. My understanding based on Ms. Bruner's responsive declaration, maybe 5:30 doesn't work. My client is not adamant that the 5:30 time occur. That's simply what the parties had been doing. As he provided in his reply declaration, the parties have consistently, prior to January, exercised visitation between the hours of 5:30 and 8 p.m. During those times, he indicates that they've never interfered with dinner or bedtime routines or the like. He is not concerned about the exact time of the visit, but simply having a specific time included in an order, I think is necessary. The ambiguity of the order is obviously a cause for concern currently. So that's with regard to the FaceTime visits. Secondarily, with regard to in-person visits, again, the court adopted the status quo at that temporary order. At that time, my client was exercising visitation with the child on his days off from work. It was included in the order that he would have 2 days on his days off from work My client agreed to enter that order by agreement instead of arguing that issue at presentation, because at that time he was consistently having 2 days off from work. It's my understanding now, and has been provided to the court, that some weeks, his schedule fluctuates. Some weeks he has 1 day off from work, other weeks he has 3 or 4 days off from work. It's his request today to modify that order to include on his days off from work, he shall have the child. In my discussion with the guardian ad litem, it does not appear that that is a concern. Obviously, I'll let her speak for herself. But there's been nothing provided to the court that would indicate that there's an issue with allowing additional day or two consistent with his days off from work. The purpose of the temporary order maintaining status quo pending the guardian ad litem investigation was entered, I believe, by Your Honor at the initial hearing, and it was intended to be a Band-Aid order pending a further review. At that further review, the court simply maintained that order moving forward. The intentions of the parties and the intentions of the court was to maintain the status quo for the child, which at that time was the child spending time with his father on his father's days off from work. My client does have a rotating schedule, so pinpointing specific days is frankly impossible. My client has made it very, very apparent that he's willing to provide his schedule, and he does so every single month that he receives his new schedule as they come out a month in advance. His days are well thought out at that point. He does provide in his declaration that there was some issue this past month with his birthday, not being able to have the child on his birthday, that Ms. Bruner and her third party dictated specific days, which is kind of giving rise to this motion before the court. That's one issue. Further, Ms. Bruner has indicated that the child participates in library activities or something of the like. My client indicates that even if that does occur on his residential time, he's more than willing to take the child to those activities to maintain that schedule for him. So at this point, Your Honor, my client feels that there's no basis to continue restricting his time as is currently under the parenting plan. That he has the support of the guardian ad litem. And again, I'll let Ms. Fellows speak for herself, but in my discussions with her, there doesn't seem to be any concerns with his request today. So we are making this request to the court. It is reasonable, despite mother's allegations to the contrary, saying that it's an unreasonable request and brought in bad faith. This absolutely needs to be more clarified more clearly, as the ambiguity is causing some conflict between the parties.
All right, thank you, Ms. Bliss. Ms. Jeffers.
Yes, Your Honor, with regard to the 2 days a week of visit, there's no need to clarify this issue. The order is very clear. As counsel indicates, the intention was to kind of go status quo, and 2 days a week is what father had off. That's what the parties had been doing. Additionally, because father's schedule is rotating, it makes it very difficult for mother to be able to plan events. It's great that father says, well, I'll take the child to scheduled activities. The problem is that father's not welcome at a lot of those scheduled activities. There's a protection order in place, one that was recently modified so that there'd be no contact, and father's behavior was in front of the other people that engage in their children in these activities. And there is a huge level of discomfort with that. In addition, that's also the reason that a third party has to facilitate all of these things. And she's been very generous in doing so, but there's a limit to how much she's willing to, exchange the child and facilitate the FaceTime on father's behalf. She has been very generous, and quite frankly, wouldn't be needed if it wasn't for father's behavior in this case. The reality is that we're waiting on a GAL report to determine if a different schedule is appropriate, a holiday schedule. And the only holdup in the case is that father has not got his evaluations as required by the court. Otherwise, we would already have that report. We've already been to court to review it, and that's the holdup. That's the reason we don't have it to date. With regard to FaceTime, there is currently a protection order against father protecting mother, and there is no contact, which means that they need to use a third party. They have been doing so. But at this point, again, father's behavior towards that third party has got more and more aggressive, which is also how his behavior has been escalating with regard to mother, necessitating a modification of the protection order. Mother has offered to set dates and times for calls, but father accepts nothing but daily. And I think that this really goes into his power and control issue, saying, I must FaceTime with the child every day. Keep in mind, Your Honor, that this is a 1-year-old child who does not talk yet. Okay. And it is mother's belief that this is just additional harassment and power and control issues. In addition, there are other children in the households They have activities, they shouldn't be able to not do extracurriculars because mom has to be home every night at a certain time. For father, it's just not reasonable. In addition to that, the other child in the house has been traumatized by father's behavior and is also now protected under the protection order, which necessitates having to get her out of voice shot. It's just not reasonable. Mother is fine having a reasonable amount of FaceTime. She proposes Tuesdays and Thursdays from 2 to 7. I think that, basically father has the child 2 days a week and he's asking for 4 days. So that only gives mother 1 night a week of freedom and make sure her other child is at extracurricular activities. It's not reasonable, not for a child that doesn't talk yet. It's just not necessary. So she would propose Tuesdays and Thursdays at 7 p.m. Mother requests that father's motion be denied or at least reserved until we have a final GAL report and attorney fees be awarded. The orders are clear. Father makes significantly more income than mother, and mother believes that this motion was brought to drain her already strained financial resources and is a form of continued domestic violence. Thank you, Your Honor.
Father indicated it's been 2.5 months since he's had any FaceTime with his child. Is that correct?
I don't know, Your Honor. The issue is not really with mother facilitating the FaceTime. It's what's been going on is my understanding between the third party and father. Yeah, we're hoping we can keep that third party.
If a third party facilitates the FaceTime, how does that traumatize the other children?
They're all in the same house. So what I'm saying is the daughter in particular is extremely terrified of him. So mother has to take her to a different location so that she doesn't freak out, because she freaks out when she hears the sound of his voice. And the third party isn't necessarily available every day to facilitate, under father's request, he wants a third party to facilitate FaceTime 4 days a week and then to arrange transportation of the child 2 days a week.
And the mother would agree to FaceTime Tuesday and Thursday at 7. Does that work?
Yeah, that's fine, Your Honor. And I think we have proposed times in the past. It's just that father will take nothing except for virtual daily.
Ms. Fellows?
Yes, Your Honor. I have been involved in this case for quite some time now. It is true that I am waiting for an evaluation. It's the father's mental health evaluation that I'm waiting for at this point in time. Regarding the issues at hand, the FaceTime visits and the in-person visits, I have access to the communication app. So I have been reviewing those as the messages come through. What I can say is that dad does try to have his FaceTime visits basically every day. He wants to have contact with his son, which I give him kudos for. But I also recognize that he oftentimes will ask, and it's like in a very short amount of time. And so I'm thinking that the other household is having to scramble to try to accommodate that. They have accommodated that many times, but I think that there was just some butting of heads and just some resistance coming from the other side because they can't always do that. And then dad feels like he's being restricted and that it's just not fair. So I can kind of see both sides here. What a suggestion would be is realistically what's being recommended by council is like Tuesday, Thursday at 7 p.m. or a specific couple of days a week at a specific time. The hard part is that dad's schedule is rotating. So I think saying Tuesday, Thursday, well, he could have those days off. He does produce his schedule. I have it right here in front of me for April. He has been providing it on this communication app. So they could kind of pencil out basically when those FaceTime visits could be when he provides it to the parties. That way they could have it on the schedule and that kind of coincides or doesn't impact his in-person visits. So I think that would be a doable kind of resolution for that. Regarding the actual visits, yeah, there was some major issues last month regarding that. Definitely some of the messages that I read kind of got a little hot. Not too bad, but it was definitely, there was frustrations. And I can understand in some ways. What I am, again, looking at April is there's basically 2 days a week that dad is off. The third week, it looks like it's a Friday, Saturday, and then the Sunday, Monday. So he would basically have 4 days back to back. And so those are 2 days one week and 2 days another week. So that's I could see where mom might have an issue about that, but that's the way they're laid out. And I think that dad should have those. It's possible that mom could have some FaceTime during that long stretch or something like that. And I think also that having the specified days and times of the FaceTime visits would help with the mom's household to make sure that the third party could have the other people out of the room, so there isn't that issue with that younger child. So I think all in all, things can be worked out with some specifics from the court. And then I do have a review hearing coming up on May 2nd, as your honor did see. Hopefully I will have all of the information, the evaluations that I need, so I can then have my report finalized.
All right, thank you. Ms. Bliss, any response?
Just briefly, Your Honor, and to answer your former question, my client has indicated that his last FaceTime visit was on January 7th. So we're going on almost 3 months at this point. While I can appreciate counsel's argument that Ms. Bruner is willing to provide FaceTime visits, the history just simply does not speak to that. He's had no visits in 3 months. Even if she was proposing 2 times a week at 7 p.m., she's not facilitated those, even with her third party. So we absolutely do need some sort of clarification as to the FaceTime visits. I'm not opposed to Ms. Fellow's suggestion that 2 times, including language that says 2 times per week, not to occur on, obviously the day that he has the child. I think that might be a way around it, given the fact that his schedules do come out a month in advance, and all 3 parties, the facilitator as well, has access to that. And so I think that may help with scheduling purposes, but simply leaving it open-ended as it is now just simply isn't working. So we do need some clarification for that. With regard to the visitation, my client's request was for clarification or modification to the visitation. So that is why we are before the court today. It is properly before the court. Following back to the FaceTime, my client provides in his declaration that he had daily contact with his child prior to this action beginning, that most of those interactions were 15 minutes max, which is consistent for kids of this age. So to simply say that multiple times a week or daily 15 minutes correspondence is unreasonable, I find hard to believe. I get it that there's some scheduling conflicts with using third parties. Again, this was the start of this action was with mother implementing that third party prior to any protection orders being used, or prior to any protection orders being entered, excuse me. So mom essentially set this into motion. We are asking the court to enter our order. Obviously, the guardian ad litem provided her 2 cents, and it sounds like she's largely in agreement. So I think it is appropriate, and we do ask the court to enter the order today.
And your honor, if I may, really quickly.
Go ahead, Ms. Fellows.
There was something brought up about the kind of the extracurriculars that the mother has Hudson involved in, and that there's concerns that dad is not welcome there. That's understandable at this point in time, but what I will say is that in the future, hopefully these parties will be able to basically settle things down and be able to do things more on a jointly basis. That said, I have talked to the mother, and she did make a suggestion, and it's a viable one, is, if there's like a library thing or whatever, is that dad could take Hudson to the local library here. We have 2 really great libraries here and could do some of those things here. Maybe if there's an exchange of different activities and things like that, dad can seek out those kinds of activities here locally. So that way Hudson is still enjoying those things, but enjoying them with dad. And that would just be a good way to be able to move forward.
All right, this is not the first case where some sort of telephonic or video contact was ordered, and initially it was left to the parties' discretion, hoping that they would be able to work out a plan that worked for both of them and to give them flexibility. And then they end up coming back to court saying either that somebody demanded too much or somebody didn't provide it. And then the answer is always to create a specific schedule, which necessarily means somebody's going to be inconvenienced. And it may be the father one week and the mother the next. But the initial order in this case calls for FaceTime visits. They haven't been occurring, and so they need to start occurring. So I think 4 days a week is a little burdensome on any family. So I'm going to take the mother's suggestion. The video calls will be every Tuesday and Thursday at 7 p.m. And hopefully the third-party facilitator will be able to make that work. I'm looking at the temporary parenting plan entered on January 23rd, and it says the father shall have 2 days a week with the child based on his work schedule and his scheduled days off. And he will provide the work schedule in advance to the mother. And the father, I think, is here today arguing, well, if I have additional days off, I should be able to have the child on all of my days off. And I'll just say that's not how I read the temporary order, and I'm going to enforce the temporary order. On the other hand, Ms. Fellows brings up a good point that if you look at what's coming up in the future, the father's off Thursday and Friday, and then apparently the way the work week works at his work, he's also off Saturday and Sunday. So he would like the 4 days. So how do we address that? And I think what we have to do is pick the time when a week ends, which wasn't defined in the initial order. And I'm going to indicate when that should be. And this, again, is going to cut both ways. 1 week, it's going to hurt the father. 1 week, it's going to hurt the mother in terms of the scheduling. But I hope it defines things. So I'm going to indicate the end of the work week, or the end of the week, is Friday at 11:59. So this particular weekend coming up where he's off Thursday, Friday, Saturday, and Sunday, that would allow him to have the child for 4 days in a row. It also means there may be weeks when he only gets a child 1 day. I don't know how all this will fall. And again, I think everybody hoped that it would be flexible and would work, but there's just been some challenges with doing that. Also, the limit will be 2 days in a week. And if possible, I would like the father to give 7 days notice to the mother. Now, that probably depends on his work and when the schedules come out. So I don't know what the restrictions are there. But if possible, I'd like the mother to have 7 days notice when those 2 days are.
Your Honor, if I could clarify
Yes, please.
briefly, is that father's schedule, monthly schedule comes out.
Okay.
So his monthly April is already out, usually the last week of the month for the following month.
For the next month.
Yeah.
So that when it comes out, if it comes out, say the last week in March for April or last week in April for March, that week, the father should indicate all of the 2 day periods that he wants to spend with his child. And then everybody can plan accordingly with that. Okay, so I've changed the proposed order from this list to indicate the telephone video calls will be every Tuesday and Thursday at 7 p.m. There was also a line, additional calls will be allowed at the child's discretion. I struck that. And then the temporary parenting plan is modified to allow the father residential time with the child 2 days a week, with the week ending on Friday at 11:59. And then in all other respects, the previous order remains in full force and effect.
And the request for attorney fees, Your Honor?
I'm going to deny that at this time. And I think it's because for whatever reason, going since January without a FaceTime call just seems unreasonable to me. That something should have been worked out. So I don't fault the father for seeking clarification, and I'm going to deny attorney fees.
Thank you, Your Honor. Thank you.
Your Honor, just a point of clarity on the point that with the set Tuesday and Thursday FaceTime visits, if he has the child on those days, are you willing to provide a provision in there that says if he has a child on those days, then the parties shall arrange an alternative day at 7 p.m. or are you just specifically leaving on Tuesdays and Thursdays?
I think just Tuesday and Thursday. If he has a child on Thursday, then there's no FaceTime, and
right,
it isn't necessary.
Okay, very good. Thank you.
So it would have to be on a non-visitation day that he does the FaceTime.
Here, Your Honor.
Right.
Thank you, Your Honor. I know I'm playing present on behalf of the petitioner, Alina Fisher.
All right.
So we're here on my client's request for entry of a default order. We were actually before the court back on February 14th. And I would note that the record reflects that Mr. Fisher was actually served with this action on January 19th, or approximately 68 days ago. We've had this was essentially our third hearing on this matter. And at this point, nothing has been filed substantively by Mr. Fisher. Originally, I had filed for default ex parte, but my documents were lost in the abyss. We did discuss that with Judge Fassett at our hearing on February 14th, and she said to simply wait and see if those surfaced. They did not surface, so I filed this motion and provided notice to Mr. Fisher. At our review hearing on March 14th, at that point, I had received no additional or new contact information from Mr. Fisher, even though he claimed that he had some new contact information and would forward that to me following our hearing back on February 14th. So I did mail everything to the only address and contact information that I have for him. We did again discuss that the default motion was scheduled for today's hearing at our hearing on March 14th as well. Those are both reflected in the clerk's notes from our hearings on February 14th as well as on March 14th. So at this point, again, we're 68 days out from when he was served. He's filed nothing substantively. My client is entitled to the relief requested. So if you're looking at the clerk's notes on February 14th, it's at the very bottom above the events where it says discussion regarding default orders. And that was for the ex parte orders. And then if you look at the clerk's notes from March 14th, at the 2:56 p.m., the second 2:56 p.m., where I advised the court that I had not received new contact information from Mr. Fisher as ordered by the court. To date, no response filed by him, and that I had noted the matter for March 28th, which is today's date.
All right, Mr. Fisher, any response?
Yeah, Your Honor, it was my understanding that given my financial situation, I'm trying to figure out if there's some sort of counsel I can afford. I haven't been able to. I'm homeless currently, so my money is going to work, and paying the guardian ad litem, that was a big bill for me and things like that. So as the way I understood is I'm trying to find counsel. I don't really understand all these processes, I'm not sure what I'm supposed to file. If I'm supposed to contact the guardian ad litem. I heard something about visitation last time, but it wasn't very clear. I don't really understand exactly where I'm supposed to go and what I'm supposed to do with this, other than the judge keeps telling me to try to find counsel. I'm having a hard time with that. I just sent a $900 cashier's check to Miss Height. I don't have much money in my bank account. I'm not getting a lot of hours at work right now. I'm struggling. I want to do what's right. I want to do what's best for my kids. I'll do whatever it takes. I don't really have many objections to what the other party is asking for. I don't care about the house. She can have the house. I don't care about cars or any of that. All I care about is doing what I need to do to see my kids, whether I have to do all kinds of evaluations or if I have to see them with a third party. None of that bothers me. I just want to be able to hug them and tell them I love them. So if you, I don't know what being in default means. I just know that if I could get some clear instructions, I'll do what you asked me to do. And maybe it'd be nice because it's been 6 months since I've seen or talked to my children.
Ms. McLean?
Just briefly, obviously the court, nor I can provide Mr. Fisher with legal advice, but the summons that he was served with on January 19th clearly outlines ways to access additional help, ways to access the forms, and what his obligations are. And so again, we are well beyond the normal time frame wherein my client would have been entitled to a default, and we're asking that the court grant the order.
I am not going to dispute that if this had gone through ex parte, it probably would have been granted. But I'm sitting here now with Mr. Fisher before me. He's not represented, and I'm very hesitant to enter a default against a pro se party. That means a party that's representing yourself. On the other hand, we need to move this along, okay? So I'm going to put this case over only 1 week to.
I'm not here in a week.
All right.
I'm out of the state.
Then to April 11th, 2 weeks. Are you going to be back then, Ms. McLean?
Oh, actually, I'm sorry. I take that back. It's the 11th that I'm gone. I thought that was next week. So I am here the 4th.
Okay, I'd like to move this along quicker. When we're done, I want you to go from the Zoom booth to the clerk's office and ask them for a form that's called a response to a family law petition. You'll need to hand fill that out, send a copy to Ms. McLean, and file it with the court.
Yes, Your Honor.
Or they'll give you directions on how to find it, okay? If that is not filed by April 4th, I'm not going to be the judicial officer that day, but I'm leaving specific instructions for Judge Fassett that if it's not filed by April 4th, then the default will be entered. That means you will not be able to contest any of the orders that your wife seeks to enter in this case. Sure. So again, it's a very short period of time. You're going to have to take care of this. Okay. Ms. Haidt, you're on this case. Any comment?
I am. I think question more than comment, Your Honor. I was waiting to see what the decision would be today before I entered into really an investigation if it was going to go into default. I do have returned intake packets from both parties, and I could go ahead and proceed, but I wondered if you felt it would be wiser to wait 1 week.
Why don't you wait till next week? Because if a default is entered, then your time may be limited at that point.
Right. All right. Thank you, Your Honor. I appreciate that.
Okay.
Thank you.
Okay. All right. Thank you, Ms. McLean. Thank you, Mr. Fisher. Okay. I have some questions for you, Ms. Thompson, but I'm going to let Ms. Bliss go first. Okay.
Thank you, Your Honor. For the record, I do represent Napoleon Thompson in this matter. I was going to address this matter early on. I've seen Ms. Thompson get on. I will just note for the court that I've received no response from Ms. Thompson. I don't know what her position is to my proposed today. I don't know if she's going to be requesting a continuance. So I would almost think it'd be more effective to ask her kind of what her thoughts are before I get too deep into argument. But I'll defer to the court on that.
All right. Ms. Thompson, can you hear me okay?
Yes.
Did you have a chance to review the temporary family law order, the parenting plan, and the child support order that was presented by Mr. Thompson?
Yes.
Do you have an objection to any of that?
Yeah.
Okay. Well, tell me briefly what your objection is, and I'll go from there.
I don't agree with days I get to see my kids. Excuse me. I want to see them every week, every weekend.
Okay. Right. What he's indicated is Friday to Sunday every other weekend.
Right.
And you want to see them every week?
Every weekend. Mm-hmm.
Okay. I guess the question is, Ms. Bliss, In light of that, do you want to go forward today, or do you want me to have Ms. Thompson file a response that's a little more formal, and then you can?
I want to file a response.
Okay.
And I think, Your Honor, I do think that's appropriate, obviously contained in my client's declaration. She hasn't exercised a lot of visitation recently, so I do believe that her request is inappropriate, but I think that the court needs to have a formal response before you to be able to consider anything.
Okay. How long do you think you need to get a response in, Ms. Thompson?
A week.
Okay. I'm going to put this out just so Ms. Bliss has a chance to read what your response is and address it. I'm going to put this out 2 weeks to April 11th.
Okay.
And so all of the orders that Ms. Bliss gave you will be addressed on April 11th, and most of those I assume will be entered. So whatever objection you have to them, you need to put in a response. Okay.
Will you?
Okay.
Your Honor, I would just ask that Ms. Thompson file those preferably by Friday. So that way, obviously the timing is going to be a little off and we're going to be on a little bit more expedited process. But my hope is that maybe she can get them in by Friday, that therefore I can get my response in by Tuesday or Wednesday next week. So that way it's uploaded to Odyssey and the judicial officer will actually have the opportunity to review it for purposes of the hearing.
So you want it in by Friday, March 31?
That's my request.
I can do it.
You can do that? Okay.
Yes.
I will put that in the order. Response by March 31. Ms. Bliss will file a reply, I guess, by April 5th. And then it should be in our system by the next Tuesday. Motion, Mr. Levitt, so we'll let you go first.
Very good.
That's correct, Your Honor. I represent petitioner LaDonna Page. And before we get started, does Your Honor have any particular order in which you'd like me to address the issues? There are many.
I know there are a lot of issues. That's why I held this over towards the end so that we could address those. I have no particular order. Just maybe say now I'm going to address child support, and then we'll go on. My notes will stay clearer that way. Okay.
All right, sounds good. I'm going to start out with the parenting plan request first. I believe that's the most important issue.
Okay.
For the parties. This family has one child in common, that is Landon. Landon is, I don't want to mess this up, I believe 10 years old. So petitioner's request for the parenting plan is that respondent have daytime visitation consistently for a period of 6 months before he's eligible to increase that, to include overnights, to include extended stays out of state, etc. This reflects his general interactions with the child for, frankly, most of the child's life. I understand that this is disputed, but I have reviewed the calendars provided by respondent, and they frankly line up pretty well with what petitioner has been saying, that respondent has been largely absent throughout the marriage. He was a pilot in the military. Then he was a civilian pilot that often involves a lot of training, a lot of a flight schedule that had him out of town for significant periods of time. We're not asking for any supervised visitation or anything like that. We're just asking that there be consistency and that the visits be planned at least 2 weeks in advance with confirmation. The proposed parenting plan says, so long as Tate D. Page communicates the plan, and then in parentheses, where and what time he will pick up and drop off the child at least 2 weeks in advance of the visit, and confirms his intention 2 days in advance.
How is it confirmed?
Text message, any form of writing is fine. We just want there to be consistency and predictability so that Landon can build up his relationship with his father, and then mother doesn't have to act as intermediary at all. We just want there to be consistency and stability. We're also asking that section 14 of the parenting plan, this is the other provisions section, include something putting forward a call schedule. Section 14A, weekly telephone video calls with the child on a consistent schedule arranged by agreement. If his schedule, because he has a flight schedule that changes regularly. If his flight schedule does not allow for consistency, then he shall send his flight schedule to LaDonna Page at the beginning of each month or as soon as he receives it, and they shall plan a schedule for calls for the rest of the month. Agreement shall not be unreasonably withheld. This would satisfy father's request to have consistent contact with the child. It's my understanding that he has been communicating or available to communicate with the child through the iPad, but there's been some frustration based on how often the child has been responding to him. All of this is independent of petitioner LaDonna Page. All of it has been up to the child, and there has been very little effort on behalf of the respondent to establish a consistent call schedule. So we're just asking that that be established. Either we have one that's a set time every single week, or if his schedule doesn't allow that, that the schedule be planned out for the month every time he gets his flight schedule for the following month. So these are all logistical issues that can be overcome. They just need to be addressed. It needs to be in writing so that we have something that is predictable, consistency and predictability. Petitioner has put in her declarations about the child's reaction to the unpredictability and the lack of consistency. I believe the child even has put in a text message to his father that he needed a break after the last visit or something like that. It's not petitioner's intention to try to alienate, punish, or separate these two. We just want their relationship to be consistent and predictable for the benefit of the child. It's not.
You're looking at the beginning, these would be day visits, not overnight visits.
That's what we're asking for. I believe, I don't know where respondent would be staying. I believe he has a sister who lives a few hours away or a couple hours away in Oregon. So at least initially we're asking them to be day visits, and then he would be eligible after several months. We're asking for 6 months of consecutive visits for them to increase beyond that, and that be reserved. So that is all I'm going to say for the parenting plan, unless your honor has any questions for me about that.
Not at this time. Thank you.
All right, thank you. Now we'll move on to child support, and then we'll get into some of the other issues. For child support, I submitted my proposed orders on the 21st, and your honor should have a copy of those. The most recent proposed child support worksheet includes it includes respondent's income based on what he said for his income from the Army Reserves over the last 2 years. He said that his gross income from the reserves was $9,091.62 for 2021 and $5,637.30 for 2022. Or I had that backwards. 9,000 2022, 5,000 2021. We add those together and divide it by 24 months, and then add that to the $1,900 that he receives for his VA disability. That would include an other income amount in his column of $2,513.71. That's how I came up with that number in his column. And then his gross wages and salaries, line 1A, is very straightforward. That's his hourly rate for flight hours multiplied by the guarantee that he has with his company of 64 flight hours a month. So that would be $7,488. And then his income taxes are just based on standard income tax calculations for federal income taxes I believe I even did filing single with no deductions. And then FICA is 7.65%. His pay stubs do not show that he has been withholding retirement, so we did not include a retirement deduction in his column. In petitioner's column, I included an analysis of her income in the sealed documents that I filed on March 2nd, and it just breaks everything down. And then I impute her up to 40 hours imputed her up to 40 hours a week, and then added in the income that she gets as a city council member for the city of Kelso. I understand that respondent wants to impute her up to median net income, but I don't believe she qualifies for an imputation based on the statutory framework as far as when you impute, when you don't. She is employed. Imputing her from, I think it's 30 hours a week up to full-time 40 hours a week would be the maximum in this case.
Let me just make sure I'm reading this right. Are you asking for a support payment of $855.98? Am I reading that right?
That is correct. And that does include the $2,000 of spousal support as a deduction from his column and an addition to her column. So I will move on to that next.
Before we move on though, Mr. Ball, the child support worksheets you filed on March 16th show your client paying $1,006.15. I assume your client would rather pay $855.
Well, our worksheet doesn't include spousal support, so that's where
it may go below 855 once you factor that in.
I'm sorry, can you say that again?
So do you think it will go below 855 when you factor spousal support in, whatever I order?
I think it just depends. Obviously, it depends on what you find their incomes to be. Okay. So I'd have to look to see what the combined incomes are with the spousal support. So the court's gonna have to decide the spousal support amount. So.
Okay, let's go to spousal support then.
Thank you, Your Honor. The parties were married in 2010. Petitioner she stopped working and was not working for their entire relationship until, and this is in her reply declaration, until October of 2020. That was when she began work. It was October 2020. She has been slowly increasing her work history and building her ability to earn an income, but because of the vast difference in income and her significant financial need, we're asking for $2,000 a month in spousal support. As an alternative, and this was in the motion for temporary orders, if her request for spousal support at $2,000 a month is not granted, then she would ask for respondent to be ordered to pay the mortgage on both houses. But the preference is that respondent pay $2,000 a month plus the required amount for child support. And
what is the mortgage on the house that your client is residing in?
It is $1,942 a month, and that includes property taxes and homeowners insurance. There were some other requests. I guess the main request that I will draw attention to is the request for a restraining order. This comes out of the event that happened in February where respondent was returning the child from a visit that did include overnights while petitioner was out of town. The exchange happened relatively late at night. I believe it was about 9:30. Respondent had said that he wanted to go in the house to get some of his belongings. Petitioner texted him back that it was late, everyone was tired, let's do this another day. When the parties both arrived at the house, petitioner got out of her car, went into the house, dropped her bags off, came back out. Her mom was there. And as she went to respondent's car to meet respondent and the child, respondent began walking towards the house. She tried to stop him. She tried to tell him that she had texted him. She didn't want him going in the house. She wanted to wait. She wanted to plan for another day. He pushed past her. Apparently he was recording this whole thing without her knowledge or consent. Went down into the basement over her objection, pushing her out of the way, and got some things out of the basement. And then petitioner did call the police. The police officer came and filed did a report, which respondent provided. But the fact remains relatively uncontested that petitioner did specifically say no, I don't want you coming in the house. We can have another day for you to gather your belongings. The respondent did not respect that request. Over her objection, went right past her, whether it is respondent's story where he calmly walked past her and she was yelling and screaming, or if it's petitioner's story that you believe where she was trying to get in his way and prevent him from getting in the house and he blew past her. Either way, he ignored a reasonable request to stay out of property that he had not lived in for months.
Does the respondent have any additional personal items at the house? Do you know?
I think he's, are you asking me? I'm sorry.
No, I'm asking Mr. Levitt if he knows. Ms. Page is indicating he does. So his presence there potentially is something that will have to happen in the future. So
potentially, we're asking for this restraining order because he has been unable to prevent himself from following simple logistical requests. Please wait. He did come back by agreement a few days later. If he had just been able to wait a few days, then this request would not be necessary. We believe it is necessary, and we're only asking that he be restrained from going within 500 feet of the home, vehicle, workplace, or school.